Let's get started with the program. I'm Mal Johnson, the Reunion Chair for class of 1963. Today we've got what I think is one of the top programs here at Amherst this reunion year. We have Peter Messitte, who's of the U.S. District Court in Maryland. He is a 63 graduate. And we have Professor Douglas of Law, Jurisprudence and Social Thought. So I will turn it over to them, and we'll go.
Thanks for the rousing introduction. And so I hope that we will have a nice, can you hear? Hello, hello, hello. How are we doing? I heard a lot of applause for Judge Messitte, less for me. Just kidding. So this is going to be organized as a discussion between the two of us, and then we hope to have ample amount of time from questions from you all. So we have a kind of a nice large group here, but we want to hear what you have to say and try to answer some of your questions as well. So let me begin by giving the podium, so to speak, over to Judge Messitte, who I think would like to start with some prefatory comments.
Thank you, Professor Douglas, and I just want to greet the class of 63. I also want to greet my wife, my daughter, her daughter, and her husband, so my daughter's husband, for being here. My daughter's class of 93, so it's an occasion. I thought it would be helpful to review a couple of basic civics points that you all know about, but they really do bear on what's happening in the world today. You know the idea of law, obviously. That's basically where Professor Douglas comes in. We do believe that law basically is an important part of society. The concept of rule of law is really a newer concept that's been discussed more in the last 50 or so years. And by rule of law, the meaning really is that you have fair and just laws, fairly and justly applied, and that the government is also covered by that. Well, do we have that? Not everybody does when you think about it. Does every society have fair and just laws? Are they fairly applied? Is the government always covered? And the answer is, of course, no. It isn't. But to the extent that those things apply in the United States, I would say we're doing pretty good. We have most of those factors that are in play. So we do have rule of law in this country. And we have a democracy. And in terms of having a democracy, one of the things that we've done, of course, there's not a democracy all over the world. That's another point, just to remember where we are in the universe. We have a written constitution, and many countries don't. Just to know about that, to keep that in mind as well. In UK, there's no written constitution, and in other places there isn't. And there may be laws that guide structure of government, but we're more or less out there by ourselves, and our Constitution, as we begin to talk about it, really is the gold standard for being around the world. And then we have we have set up a system of checks and balances in our Constitution. And the classic terms are that the executive formulates the law, the legislature enacts the law, the judiciary enforces the law. Now, keep those concepts in mind, because it's not really what's always happening in the world today, particularly when we talk about the judiciary and the Supreme Court. The other concept that you have heard about, I know, but is really in many ways more unique to the United States, there are other countries who share the concept, is the concept of judicial review, which gives to really any judge in the United States, at least a judge of a court of record, the right to declare laws of the executive, laws of the legislative unconstitutional, and basically have the final word on what should be the law that's applied. Well, in some countries, they don't have judicial review, or nothing as robust as ours, in the sense that, for example, in the UK, when the Parliament enacts a law, there's no judicial review of that law. There may be judicial review of arbitrary administrative acts, but in terms of laws enacted by certain executives, legislators, whatever, the United States has judicial review. And that's important because obviously what we're talking about with the United States Supreme Court is judicial review. I mean, that really is the core of what we have. So those are basic concepts that to keep in mind. And then a couple of other points to bear in mind. We're a federal system. Federalism, remember, 7 individual colonies, and we came together and formed, hopefully, a more perfect union. But the point is, this idea of state sovereignty is still out there. We're seeing it every day, and it's playing very much into what I think you will be concerned about when we talk about the Supreme Court. And then just finally, as a preliminary word, I would say bear in mind the structure of our courts. We have federal courts, we have state courts, and basically they are structured by having a trial court system, often an intermediate appeals court system, and then at the top, particularly in the federal system, we have the U.S. Supreme Court, and in the states, often there's an intermediate appeals court. So there's a structure. And the trial courts are supposed to hear disputes in the first instance, meaning they actually take evidence and they render decisions, and then to the extent that there are arbitrary decisions made at the trial level, or not even so, there's an appeal of right to the intermediate court, and usually to the state high court, and certainly to our federal court, Supreme Court. There's a discretionary review. You've heard of the writ of certiorari. Our United States Supreme Court probably gets 5,000 or 6,000 petitions a year, and it renders decisions in maybe 60 or 70 cases. And because they're not taking every case, they're not reviewing every one. So these are all concepts to keep in mind as we go forward and talk about what's going on today. And I perhaps will come back and say one or more things about it. But I think that's as much as I need to say about background. And perhaps, Professor Douglas, you want to take over at this point and pose some questions for me?
Yeah, well, actually, maybe the first question I'll ask you goes to the public's perception of the Supreme Court these days. I think we're pretty familiar with Congress having low disapproval numbers. But as a historical matter, we're usually pretty accustomed to the Supreme Court enjoying relatively high approval numbers. We've seen moments in history where the Supreme Court has a dip in its approval rating. We saw that in 2000 after its intervention in the 2000 election in the case of Bush v. Gore. But now we actually see the court recording some of its lowest disapproval rate, or its highest disapproval ratings of all time. Depending on which polls you look at, between 58, 61% of Americans disapprove of the work of the Supreme Court. So I wonder if you have any thoughts about that, about these record disapproval numbers of for the Supreme Court.
I don't think there's any dispute that the Supreme Court is not esteemed today the way it once was. And it wasn't so long ago. We're talking 2010 even, that the Supreme Court was really, of all the 3 branches of government, the most highly esteemed. And now it's flipped. We are, instead of having a 60% plus approval rating of our Supreme Court, it's maybe 40. And that's distressing. I would say, though, it's not entirely new. I mean, some of us who are old enough to remember the Earl Warren Court, remember the old impeach Earl Warren activities when the court was going pretty far to the left and establishing the rights of criminal defendants, one man, one vote with regard to voting. There was a lot of activity against the court, but nothing like what we've seen today. The numbers never really dipped the way they have. And I think at the core of your question really is why? Why are we at this point? And I think you can pretty much identify why the court is not as highly esteemed today as it once was. First of all, just in the last few years, we have had precedents that have been disregarded. You know, the precedent following the decisions of higher courts in the past gives stability to a system. It's predictable, it's fair, and so on and so forth. If you scrap the precedents, you're creating instability. And we've had some very significant scrapping as recently as the last couple of years. Not this term so much yet, but last term was just radical in terms of what the court did. So the fact that there has been a rash of serious dislocations, I would say, rejections of precedent, changes. That's one thing that I think has caused concern. And we're talking about abortion, we're talking about gun rights, we're talking about gerrymandering, we're talking about corporate spending. I mean, everything that you have read about over time, these things are all coming to the fore and causing great concern for a lot of people. And the court appears to be very political. And if you ask my opinion, I think they are. I mean, that's hard to escape. John Roberts once said, all we do is call the balls and strikes. Well, not really. I mean, there are some statutes that may be easy, but if they're that easy, they're not going to the Supreme Court. Even statutes are ambiguous, that the kind that and are important enough that get to the Supreme Court. So there is some interpretation. So the balls and strikes analogy really doesn't fit very well for where we are. And what else should I say about why there is some lack of esteem for the court? Frankly, there's a real arrogance on the part of the court. I mean, that's really troublesome. If you, for example, look at some of the opinions that Justice Alito has written, or Justice Thomas, they say things like Roe versus Wade was egregiously wrong. This is one guy in 2022 saying it's egregiously wrong. And 50 years ago, some rather wise judges, including at least one Catholic judge, Justice Brennan, said, no, this is the way it should be. This is the way the Constitution should evolve. You have Clarence Thomas saying, this opinion misreads the historical record. Well, where's he coming from? I mean, there are a lot of people, a lot of judges in the past, justices who've made these decisions, and to simply say they're wrong, they're egregiously wrong, they're flatly wrong, it's that arrogance, I think, that is troublesome to a lot of people. Some of you have probably read about the shadow docket, where the Supreme Court hears cases on an emergency basis and usually issues a stay of the decision of the lower court in order to preserve the status quo. In the Trump administration, they went to the Supreme Court more than 40 times on these emergency petitions, and well more than half were granted by the court in matters, for example, as easy example would be employers who were seeking to either have the employees, large employers, tested or vaccinated, stayed. Just no briefing, no explanation, just a kind of a written opinion. That kind of shadow docket is troublesome when you have that sort of thing. And as I say, the words, the reasons that are given are troublesome. And there's a certain hypocrisy that's out there. Go back and think about how some of these justices got confirmed, the confirmation hearings, what they said when they were asked about precedent. What are you going to do? Justice Kavanaugh talked to Senator Collins, who said, I'm for this guy now because he's told me he's going to stand behind the Roe versus Wade. Well, what happened? I mean, that's the kind of thing. And you got the same kind of candid waffling by Gorsuch, and you got it as well by, not as much by Barrett, because she was on record as saying basically abortion is a historical barbarity. We'll come to that about how that happened. So those factors of hypocrisy, political activity, the recent rash of these decisions, it's troublesome. And then we'll come to this, I think, perhaps more separately, but the whole issue of ethics, which is going to factor in, perhaps we can talk about that as later on, but what are these guys doing? How are they getting all these benefits and not accounting for them? Is this the appearance of justice? So when you go out to ask the public, how do you feel about the court these days? They could point to one or more or all of these things and say, this is why I don't have a great esteem for the court today. So that's, I think, as much as need to be said at this point.
Well, maybe I'll play devil's advocate for just a moment and maybe suggest, first of all, that maybe it has less to do with overturning precedent, being kind of arrogant in the rhetoric, and just that people disagree substantively with the decisions that the court is making. They just reject the decisions. They think they got it wrong in Dobbs. And then on the other hand, to then point out that, well, the Supreme Court is not supposed to be a majoritarian institution. I mean, isn't the whole theory of the Supreme Court is that it's supposed to, in a certain way, resist the wills of democratic majorities? And so the fact that the Supreme Court is not particularly popular with the democratic polity, is that really a criticism of the court, or is that really an indication of the way it should be functioning? I mean, should the court be basically following the basic political directions of the country, or is the court supposed to be doing something that other than what majoritarian branches of government do?
Well, there's something to that, but I think, the idea of law needing stability, needing predictability, should mean that with every new appointment to the court, there's not a flip in what happens. I mean, we're getting 5 to 4 votes over the years. One guy or one woman, mostly it's a guy who makes the decision. Maybe Amy Coney Barrett would qualify in future. The other women are obviously in the more progressive left wing where you don't have things being turned over. But you've got a flip that's happening very quickly and very radically. And I think that really is the countervailing consideration to the fact that, okay, you make decisions that you think are right and so on. But look at some of these cases where a decision was made, Citizens United, which basically said a corporation is a person. 7 years before they decided Citizens United, they could affirm that the fact of a limit on corporate spending was okay. 7 years before. More than that, that issue wasn't before the court. The court reached out and asked the people to rebrief that point. Now, these are all matters of concern when you talk about, is the court changing or should it be changing along the way? I'm a great believer, and I think many people are a believer in what I would call incremental constitutional change. And we're going to get to that in a few minutes when we talk about originalism versus living constitution. But things do change, but they change slowly over time. It's the way the common law works. It doesn't change in a day. It accommodates newer situations, which I think I need to talk about more specifically when we get to the idea of the doctrine of originalism. But again, I think right now our experience has been in recent years, it's happening awfully fast. And there have been these radical changes with the changes in personnel in the court. And that's Justice Kagan said in the Doe case, the only difference between this case and the other case is change in personnel in the court. That's what's happened.
Well, since you brought up originalism, why don't we talk about that for a moment? And maybe it would be helpful for you first to explain to everyone what we mean by the doctrine of originalism as a form of constitutional interpretation, and then also to kind of maybe deal with the question of, so you've said that the overturning of precedent contributes to a kind of lack of predictability in our law and maybe has led to an erosion in the respect of the Supreme Court. But if it is the case that justices believe that earlier precedents simply misread even earlier history, isn't there a case for correcting the precedent in light of original historical understandings? So maybe you could talk a little bit about that.
All right, something to unpack there. Maybe the way to talk about it is, what is the appropriate mode or manner of interpreting the Constitution? Number one, the Constitution doesn't say anything about that. It's completely silent. So the idea of how you go about interpreting the Constitution is just something that's grown up over the years. And basically the court, has gone along over time making decisions. I would say it's reasonably conservative up until the 50s, on and off. If you remember Roosevelt's contention with the New Deal, and a lot of his administrative decisions were being overturned by the Supreme Court, and then they had what they call a switch in 9 saves time. One of the justices changed his mind, and suddenly the court was approving all this New Deal legislation. Really, with the Warren Court, you did have some radical changes where you got the idea of enough third degree for the treatment of criminal defendants. Let's give them rights. Let's establish that they're given certain warnings. Let's recognize the right to counsel, which after all does say in the Constitution you have a right to counsel. You have a right to be represented by an attorney. But what if you can't afford one? Then the court steps in and says, well, you've got to provide one, and so on. So in the 50s, particularly the Warren Court, you get these decisions which are beginning to correct serious social situations. And of course, it culminates in Brown versus Board of Education, which is the super precedent of all time. I'll come back to that in a minute because it's an interesting point of contrast. But there you've got the court saying separate but equal is inherently unequal. You've got them making that kind of a statement. And slowly, even though court was under Berger and some others, Nixon appointees all, Harry Blackmun being one, for example, who authored Roe versus Wade, they're still kind of going along with some of these precedential concepts. And candidly, it really begins to change with Robert Bork. Bork gets nominated for the court. Bork has on record, and maybe that's a bad thing if you want to be a Supreme Court justice, is basically saying Brown versus Board of Education is totally wrong. There's no basis for that in the Constitution at all. We have to go back to the original meaning of the Constitution. And there's nothing in the Constitution that talks about school desegregation. We need to either divine the intent of the founders, or as this concept has developed over time, let's find out what the public meaning of the words were in the Constitution or the amendment at the time it was enacted, and then that becomes our fixed star. We don't vary from that. We don't accommodate for modern change. We don't accommodate for balancing the factors to come up with a new vision of what equal protection of the law should mean, or even cruel and unusual punishment. These terms are awfully vague. Equal protection, due process of the law, cruel and unusual punishment. What do you do with these terms? Do they mean what they meant in when? The end of the 18th century? I mean, do they really? Is that what you want to say? And to some extent, that is where you end up with the originalist view. The key factors of the originalist view of interpreting the Constitution are, one, what's the reasonable public meaning as of the time that the statute or provision was enacted, including the constitutional, and that's fixed. That doesn't change, and you don't get into weighing factors. The contrast to that is what has come to be called the living Constitution view. And that's where everybody starts with the text. You read the words, they say what they say. And then what do they mean? And do they mean exactly what they meant in the 18th century? Or do they mean what they mean today? How do you work with that? And then they start to weigh what are the effects of coming out, consequences of coming out one way or another. And maybe modern times do demand modification. George Washington had no experience with the internet. I mean, that's kind of the issue you have to deal with in a word. You have to figure out how do you apply those concepts today. So that's the living Constitution concept, and it really stands in contrast to the originalist view. Now, originalist view is absolutely in ascendance today. There are 9 justices on the court, and 6 of them embrace that view. And the person who popularized it after Bork was Antonin Scalia. Scalia was bright, sharp, sarcastic. He came up with a view that the original view was what should prevail. And that battle is going on even today. You could characterize the 3 center-left justices as being more attuned with the living Constitution. Just a word or two about that, though, because I don't see this often in the literature, and it's important. You know, I'm amazed how the narrative of the right has captured the idea of activism. It's all of us on the left, I guess I'm one of those, who are activists, but nobody on the right is. And think about that. I mean, what's been going on? It's just not so. It's just not so. And yet the dialogue has been such that, you know, to call somebody a living constitutionalist is to say something bad about them. But there are ways, and those of you who are lawyers, and I see some of you out there, I know this, you don't just decide a constitutional issue right off the bat. There are very limiting ways in which issues even come to the court. You have to have a case or controversy. You have to have standing. You have to be somebody who's really been injured. I'll come back to that with the Mephistophelian case, because that's a good example. Do the doctors who went before the judge in Amarillo, Texas, really, were they injured by what happened in the FDA 20 years ago? I mean, that's an interesting question. What's going to happen with that case? You know, right as it happens, the shadow docket rejected the suspension of that decision. They come back yet. But you have not only the idea of a case in controversy and yet the idea of standing. The case has to be ripe. If the issue isn't really out there and has been developed, you don't answer it. There are no advisory opinions that our court gives. Some, by the way, do. Some courts in other countries do. Very familiar in Brazil, where I've spent a lot of time and worked. They give advisory opinions on what the constitutionality of a statute is going to be. We don't do that. And it can't be moot. It's got to be an issue which is still alive. Still, it's not something that simply disappears because somebody has gone the way. And that issue comes up all the time. I might just give a word. Some of you perhaps know that I was involved with the emoluments clause under the Constitution when Donald Trump was still receiving a lot of money through foreign people patronizing the Trump International Hotel in Washington. And I had to get into that very issue of what was the meaning of the term emoluments. Well, my read of it was, based on what the experts were telling me, was it meant any kind of profit advantage or advantage. And yet other people said, no, he's giving quid pro quo. If he's got a hotel and he's getting money for it, that's okay. But that's not what the emoluments clause said, at least in my view, and it's not what the word meant. Emoluments meant any kind of profit advantage that you get from a foreign government. And the Fourth Amendment said you can't do, not the Fourth Amendment, Article 4 said you can't do that unless you get the consent of Congress. Well, Trump never got the consent of Congress to go forward with the hotel. And then later, afterwards, the idea of the meaning of emoluments, there was a professor at Georgetown Law School who did a computer search and came up with 2,000 definitions from all sorts of literature that were contemporary that accorded with my understanding. I didn't have that kind of database, but that gives you some idea. But what happened? There still was a very strong opposition to my view that the emoluments clause included the kind of receipts that Trump was getting through the trust fund that ran the hotel. So those issues are still very much alive. They're coming out all the time. I don't know whether maybe I went beyond where you were. But.
Well, actually, let me just echo one of the points you were making about originalism, because I thought you made the important point that originalism often packages itself as a kind of conservative jurisprudence against the kind of activist jurisprudence of living constitutionalism. But I think your points actually alert us to the fact that the originalist position, it can be really a quite radical position, because it justifies overturning a tremendous amount of precedent that has evolved over the course, arguably, of centuries in the name of some original understanding from the late 18th century. I mean, I'll give one example, just let's say from the Second Amendment context with regards to the right to bear arms. Between 1791 and 2008, the number of state regulations that were declared unconstitutional, state gun regulations that were declared unconstitutional by the Supreme Court, again, from 1791 into 2008, that number was exactly 0. The court had never done it. And then suddenly in 2008, in Heller, this Heller v. D.C. court case, the court suddenly discovered a personal right to gun ownership that
including AK-47s, by the way.
Yeah, and suddenly discovered that there was a personal right to gun ownership, basically overturning a couple of centuries of constitutional understanding. I'll also just to highlight how outlandish that conclusion was, this is a quotation from Warren Burger, and you might recall that Warren Burger was a conservative justice on the Supreme Court, and who replaced Earl Warren as Chief Justice. Remember, this was Nixon's Chief Justice, Warren Burger, and he said the following about the idea that the Second Amendment creates a personal right to gun ownership. He said, quote, "It is one of the greatest pieces of fraud, and I repeat the word fraud, on the American public by special interest groups that I have ever seen in my lifetime." And again, it just kind of like highlights the degree to which that kind of originalist understanding can really be a quite radical form of constitutional interpretation rather than a preservative or conservative one.
Absolutely, and Justice Stevens, who really was one of the greater justices of last year, said it was the most, Heller case, the most incorrect decision that on the 30 years or so that he has ever saw in the court. He said, I almost resigned in distress over that decision. There you are. That's where we are, and it's a serious debate. But bear in mind, originalism is holding sway in the Supreme Court today, and it will, and given the ages of the justices, the three most recent in particular, it's going to be in place for a long time.
So I'm going to ask you just one more question, and I'm going to open the floor up to questions. So as I ask this question, you can now be formulating the questions that you want to ask either the judge or myself or both of us. Given the problems that we now see with the Supreme Court, are there any reforms, like if you could push a button, is there anything that you would change? Would you introduce term limits? Would you pack the court, as FDR proposed doing at the time of the New Deal that you already alluded to? What do you see as the kind of proper or maybe necessary response to some of the problems that you've articulated?
Well, this issue, of course, is out there. It wouldn't just be my opinion. President Biden appointed a commission, presidential commission on proposed reforms of the court. They were academics, they were lawyers, they were judges, they were business folks, and they came out with a 300-page document which doesn't really say do this, but they really analyzed what the options were. So it's being discussed. And there are a number of options. And the one that's probably most broadly supported, I would say bipartisan, although don't want to go too far with that, would be the idea of staggered term limits. Instead of having life tenure, and one of the questions asked this morning at President Elliott's presentation was about tenure for professors. Well, tenure for judges, should they have life tenure? I mean, for me, it's great. It keeps me going for a long time. But the fact of the matter is that you get people that get sort of frozen in their position, they get older and so on, and the idea of staggered term limits would give different, perhaps judges, different presidents with different philosophies an opportunity to put people that are more attuned to their view in place. I mean, Trump got 3 appointments. That's extraordinary. I think Obama got 1 and didn't get a second even during the 8 years that he was in office. 2.
Yeah, 2. Yeah.
2, got 2. But I mean, look, Trump gets 3, and frankly, Senator McConnell didn't play fair, if you remember the Merrick Garland case. So you're not getting those kind of changes. That's obviously wrong. So the idea of staggered terms is fine. But, it wouldn't be impossible to have age limits. All the states do, for state judges, have age limits, usually about age 75. Now, I'm beyond that, so I'm not in favor of it, but and for federal judges, forever. But you could have age limits, as most states do, most countries do. You could have age limits. The idea of mandatory retirement exists at many state levels, and of course many governments around the world. Age 75 thereabouts, you got to step down. That's it. Is that a good thing? Well, arguably, yeah. I mean, it could be so. It depends on where you stand in the age spectrum. But yes, there's that. The idea of increasing the number of justices on the court, it's been out there over the years. We've had, and I'm going back to the 19th century, 5, 7, state where we were at 9 since about the mid-20s. Could be bigger. Other courts, France has 11, UK has 12, Spain has 15. I mean, you can have Supreme Courts that are large. I don't know that we're going to find much opportunity for that. Roosevelt got knocked down pretty hard when he talked about expanding the size of the court. But the things, as I say, the staggered term limits, probably a good idea. Age requirements might be okay. I don't know that we're going to see the end, though, of some of these other aspects. But it's being discussed. Something is definitely going to happen, I think, over time. But as long as one wing of the public holds the legislative power, and this, by the way, could be done by ordinary congressional legislation. Sure. Well, the Constitution doesn't tell you how many justices you have to have. You don't even have to be a lawyer to be a judge or a justice. Doesn't say anything about lower court judges. So this is all within congressional control. Well, the idea of whether Congress would act, reasonably under the circumstances. I mean, One of the reasons why, frankly, at the bottom of all this, what the court has done over the years is congressional gridlock. You don't get anything done in Congress. They don't change. And this will show itself in a number of ways. One final comment to make, because this case could come up by tomorrow or next week anyway, and that's the issue of giving states the authority to say what it takes for federal elections. Essentially gerrymandering. Do the courts have any role? And the answer is maybe not. Maybe not. And then what? Well, take it.
Yeah, so actually, let's open up to the floor. And I think we have actually microphones. So a microphone will make its way around. And why don't you, I'll leave.
Peter, or either one of you, could you comment on the effect of the Heritage Foundation against some of the things, the changes that have happened in our lifetime?
I'm sorry,
The Heritage Foundation, I think, was the question.
Can you comment on the Heritage Foundation's effect on some of the changes that we've seen in our lifetime, not only on Second Amendment, but others, and then maybe answer why organization, because my belief is, certainly in the Kavanaugh hearings, if they had spent their time educating the American public on how Mr. Kavanaugh got to his positions rather than his teenage years, he might not have been on the court.
Well, I think you can maybe even broaden the question. What about the interest groups that have been influential in what's happening with the court? The Heritage Foundation is certainly one, which has, and in some ways, I suppose, permissibly, arguing for a certain point of view with regard to how the Constitution should be interpreted. There may be a lot of money involved there that goes into this whole idea of no limit on corporate spending and so on, the extent to which they're involved in vetting people for positions on the court. You can talk about the Federalist Society as well, which is very much...
Which is certainly more influential than the
more influential than the Heritage Foundation. The Federalist Society is a group that's led by a guy named Leonard Leo, a great friend of Justice Thomas and others, and they are dedicated to the proposition that originalism is the only correct interpretation of the Constitution. Members of the court, of the conservative wing of the court, are also members of the Federalist Society. The whole idea of farming out who is going to bring in potential justices is left to Leonard Leo and the Federalist Society. They vet these guys. And the idea that our justices our members, and then go to these meetings and promote these people is troublesome. The last three appointees by President Trump were all vetted by and promoted by the Federalist Society. And is that a good thing? Well, I mean, they have a point of view. Is it the kind of thing that we should permit? I'm not sure we can prohibit it, but it does represent, you need to understand what's happening, that there are groups dedicated to promoting one point of view with regard to the interpretation of the Constitution, which I think we've talked about a bit, and they are out there and they're doing it. And the Heritage Foundation is doing in the same way, the same kinds of promotion. And there's not much to say. A lot of it has to do with the spending of money, for example. If they're into campaigns, shouldn't there be a limit on campaign spending? Well, ask the court and talk about Citizens United. I mean, those cases are out there and they're troublesome. So, I mean, in some ways you can't control it, but you should be worried about it. And I don't know if it's constitutional to say a corporation is a person and you can't have any kind of limits on spending. You need a constitutional amendment to change it. You can't do it by ordinary statute. That's where you're sort of locked into these positions when they're declared to be constitutionally or unconstitutionally based. Ordinary statute won't correct it. But with regard to the qualifications of justices, you could have that. Someone's going to ask a question about ethics in a minute, but I'll just jump into this question. The whole idea, for example, of whether the Supreme Court should have a code of ethics. They don't. I do. Lower court judges do. But that's not something Congress has authority to require them to have it. They may not want to do it, but they do have the authority because there's nothing that says they don't. Now, Chief Justice may disagree with that, but, and what would you do if he says, well, it's unconstitutional, you can't do it? See, he's the guy in charge, I guess. He says it. Wait.
Actually, let me just follow up very quickly on the role of the Federalist Society. I mean, one thing we should also remember that there was a time, not in the relatively recent past, in which the ideological positions of presidents often did not align themselves with the constitutional jurisprudence of the members of the court. So you have people like Justice Stevens, who was nominated by Republican President Ford. You have Justice Blackmun, nominated by Nixon. You have Justice Souter, who was nominated by the first Bush. They were all very liberal members of the court, and they were all nominated by Republicans. And I think in part the Federalist Society was born of the effort to kind of make sure that there would be kind of greater ideological discipline in the selections on the part of Republican presidents.
Yeah, and just an interesting historical note, some justices have come to the court and completely turned around on where they were before. Like Hugo Black was a member of the Ku Klux Klan, became the most liberal justice probably in history. Felix Frankfurter was a very liberal civil libertarian when he was a law professor, and then became one of the more conservative members of the court. It just has happened. But now there is such a careful vetting that's going on. It's a litmus test, and there was no question. Trump ran on the platform that I'm going to find people who will overrule Roe versus Wade. And the Federalist Society administered the litmus test to people who they knew were going to vote that way, like Amy Coney Barrett, who had written this article calling Roe versus Wade an historical barbarity. I mean, that kind of thing is not going to happen in the future with that kind of control that organizations like the Federalist Society have over the nominations. And there's no clear path to a different outcome. I mean, I might say that. That's part of the distressing part of where we are. What will cause things to change? Don't know.
Yeah. Sir.
So this may be a question more for you, Professor Douglas, than Peter. So at one point it was said that even in the Supreme Court that the justices read the election returns. That used to be sort of a standard line among political scientists interpreting this. So how do you may not, you could confirm or deny that. And the question is, how would you
I'm having a little trouble hearing you. Maybe you're speaking for everybody, but your mouth.
Judges listened to the election returns, right? So they listened to the people in the form of how they were voting, and that I think the one view was that was how the Warren Court in particular they made a number of its reforms, and you could even say it was also to some degree involved in the marriage decision, right? That it was reading of the election returns or the public opinion as expected. But that doesn't seem much to be there anymore. I mean, maybe you Professor Douglas, want to say that it was never true. But how would you respond to that?
Okay, if I got the question right, and feel free to correct me because I might not have, I think you're asking about the relationship between the court and the general views of the electorate and how closely the court should either align itself with the general views or move away from it. And some of you, I don't know how many of you were students of Henry Steele Commager, the great Amherst historian, so I see a number of hands going up. So Henry Steele Commager actually wrote a book all the way back in 1943, which I continue to teach. This was a very short book called Majority Rule and Minority Rights. Majority Rule and Minority Rights. And, one of the things he points out is that, when majorities, when they impinge on the right of minorities, that really is a reason for kind of an active judicial review. Majorities tend not to act adverse to their own interests, but they historically tend to act adverse to the interests of minorities. And so I think that becomes a very potent reason for the Supreme Court to intervene. But it raises the question of what are the minorities that the court should be intervening to protect. And I think those of us who were, let's say, grew up during the Warren Court came to believe that the court should be intervening to protect what we might describe as discrete and insular minorities, historically disadvantaged groups. Henry Steele Commander in 1943 made a canvas of American history and said, those are not the groups that the Supreme Court has historically intervened to protect. The groups that the Supreme Court, the minority that the Supreme Court has historically protected are landed, wealthy white people. And the Warren Court was, I think, kind of a happy period in which the court kind of now answered its promise. This is the reason why we really want to have judicial review. But we might say that what we've seen in recent history, in recent years, is kind of a return to the phenomenon that Henry Steele Commander was describing, that when the court now acts, it basically is acting as it did through much of American history, which is to protect the rights of the privileged and the elite. And that seems like a kind of regrettable situation.
Well, I may say I took a course with Commander, as did my daughter 30 years later, and I thought it was all about beer and pretzels. That's what they called the course in those days, as I recall. He was impressive in a lot of ways. I don't remember him ever raising that point, though.
Yeah, yeah. It's a wonderful little book. Wonderful
I'll
little
have
book.
to check.
Yeah, yeah. Yes, sir.
I think, I'm a lawyer, but I was an activist at Amherst long before that. And I think the problem with the court is the problem of democracy in America and the original sin of America, slavery, because an electoral college in which the minority has chosen the presidents, Republican presidents, above all Gore and Trump, gave them an ability to appoint justices so out of touch with what the majority of people wanted that I think that's an underlying reason, our lack of the limits of our so-called democracy compared to France or Britain, where majority rules. So I think in 2000, for example, literally 10,000 black voters were purged by a Republican company from the voting rolls of Florida, which gave the election to Bush, not just the Supreme Court. And if Gore and one senator had joined the Black Caucus and challenged that, you could have had a different result, a legitimate challenge, unlike Trump. My question is really about, a decision that may be cooking around the court. You alluded to a bit. The problem with court, the notion that state legislators' supremacy, that a state legislature cannot be challenged on constitutional grounds. Now that they've taken that right away in the federal area, the states are the last bulwark. My understanding is that case is in front of the Supreme Court. It could lead to the situation where the state legislatures could nullify the majority vote in the Electoral College. So if you could perhaps give some insight where you think the court is on this. I think it's almost like 4 of them may go for this notion. I mean, that would be the eradication of even our imperfect electoral college.
Are you saying that the one interpretation could nullify the vote of the Electoral College?
Well, my understanding, there's a case in the Supreme Court right now.
Yeah, the Moore v. Harper.
Moore v. Harper, which is talking about the notion that a state legislature, now that they're all gerrymandered because of the dark money that gave them in 2010, most Republicans dominate the state legislatures. Now, this notion of a state legislature cannot even, it's, let's say,
Yeah,
a law
let
to
me
restrict
explain. Maybe
voices.
we can just quickly explain.
Right, yeah.
So Moore v. Harper is a case that was argued before the Supreme Court earlier this year, actually technically last year, and will be decided probably by the end of this month. And the issue there was something called the independent state legislature theory. Now, again, theory might be too generous a term to describe what was at stake here, but basically the idea was that a state legislature would have plenary control over the election results within a state, notwithstanding anything else, even in the state constitution or any action on the part of the state Supreme Court. And I actually, however disappointed we are with the present Supreme Court, at least from the oral argument, it does seem that that radical theory of this independent state legislature is not going to fly. In the oral argument, Amy Coney Barrett really tore it to shreds. And so at least in this one particular case, I think the Supreme Court is going to do the right thing and not buy into this really radical independent state legislature theory.
Well, I would agree with that, although you never can tell where the court is going to come out on these issues. The concept of this independent state legislature theory goes back to a concurring opinion that Chief Justice Rehnquist wrote in Bush versus Gore. Nobody's supposed to be citing that case anymore. They said, no, this is a unique case. It has no bearing on the future. Well, look where we are. Now you've got a number of members of the super conservative majority who say we think this is a valid concept, but how far they will go, I don't know. Maybe I'm a little less sanguine than Professor Douglas about this. I don't know the answer to that.
Yeah. Actually, I'm going to just follow up maybe one other point. I think you mentioned the Electoral College as well, and also yeah. I mean, one thing we've been focusing on with problems of judicial review and the contemporary practice of the Supreme Court, though, you know, the greatness of our Constitution notwithstanding, unfortunately our Constitution, at least I would argue, has some pretty serious defects built into its structure. And one of them clearly is the Electoral College. The Electoral College is a disaster. And no, really, I mean, it is. It's a, you know, at best dysfunctional and at worst dangerous. I mean, it leads to the outcome that we've seen already twice this century, in which someone who does not win the popular vote can be elected to the highest office in the land. And the other thing to bear in mind is even in something like, 2020 election, where Biden wins the popular vote by, over 7 million votes, not a landslide, but a substantial victory in the Electoral College vote. If Trump had gained 44,000 more votes in Arizona and Georgia and Wisconsin combined, you would have had an Electoral College tie. And that is a catastrophic situation. And so it really has a real distorting effect on democracy in the country today.
But it's in the Constitution.
Yeah.
And you don't just have a congressional law that changes it.
Right.
And getting a constitutional amendment ain't going to happen.
Okay, let's go with one more question because we're just about out of time. So
You can choose. Go ahead.
pick. We've got two that have been monitoring the
You
the
go for it.
audience. Go ahead. Okay.
We have.
Thank you. Let me first take 10 seconds to say that Professor Douglas inspired me to go to law school, and 10 years after that, I have not regretted my decision.
Oh.
So thank you. In terms of my question, it's pretty broad. We've heard a lot of what seems to be going off in a very concerning direction with the Supreme Court. Are there words of encouragement? Are there silver linings? Are there undercurrents maybe at the district court or appeals court level that either of you gentlemen could offer to give us a little more hope, after all of the... And to give one example of what's concerning, for a long period, the court was a bastion of objectivity and decency, at least in contrast to Congress. We had a great friendship between Justice Scalia and Ruth Bader Ginsburg, and it seemed to at least have civility and discourse. That both of those luminary minds are now gone. So are there, and that's just one example of the polarization and lack of understanding, though, are there openings and reason for hope that you see in the coming years? Thank you.
I would not give too much credit to the fact that Ginsburg and Scalia were friends. I mean, in the end, it's what kind of product they're putting out, and they were radically different, and I don't see any hope for personal friendships. They can be friendly as they want to be, in chambers, but the decisions that they put out are what really matters. Right now, I think we're in a perilous time. I really do. And I don't see things happening quickly. Before Mal, you adjourn, there are just a couple of quick points I want to make that are not responsive to questions, but I think that I need to throw them out. One is the Dobbs case, the abortion decision, is by far the most important one of recent years, in my opinion. Millions of lives are obviously affected about it in an immediate way, even in a way that the gun control cases are not affected by it. That's my view. The other thing is there's a serious ethical question that's going on in the court right now. You read about Justice Thomas taking these undeclared yacht trips and vacations. His mother's house was bought by a Texas billionaire, and she lives there rent-free. The tuition of his grandnephew was paid for by this same person. Justice Gorsuch sold some property to a big law firm, which was not selling until he joined the court, and so on and so forth. There is no code of ethics for Supreme Court justices. There needs to be, in my view, there will be, and that perhaps is a good sign, and Congress will do it. Although the Chief Justice declined to appear before the Senate Judiciary Committee and talk about it at all, Congress can enact a code itself. And if they do that, you may see some writing of the balance there. But it's an uphill battle.
Question for...
Wait. No, yeah, we're out of time. Let's hold it.
Yeah, okay, go ahead. Sorry.
All right.
Yeah.
Give that one.
Sorry.
Yeah, the white shirt.
I appreciate this.
Yeah.
And I understand you're out of time. We all are. This is a wonderful conversation. You started by talking about the rule of law. When are we going to stop following the law if half of the country has been deemed not a full citizen anymore, which is what happened with Dobbs, etc. To stop following the law. I sat at Johnson Chapel and listened to this wonderful president of this college say, we will follow the law, given that we're soon going to be dealing with another Supreme Court decision coming down. When is it like to stop? I say right now.
Well, I think we're out of
is like
time.
an
Did we say we're out of
encore
time
question.
or anything like that? No. I do think we have to be, I mean, just from my own point of view, when you're in a world of open defiance to the law, that's also a world of hurt. That is also, we're talking about, if you're talking about the enforcement of the Fugitive Slave Act, that might be an example in which you want to engage in open defiance of the law. But you better be awfully certain about the egregiousness of what the law is doing before you engage in open defiance. And again, it also raises the question about who is engaging. I mean, is it absolutely warranted for the American people to try to use their elected representatives for the purpose of trying to get the legislative change that they want? 100%. But that's what I would like to see. And I would actually like to see it among Amherst students as well. I'd like to see the kind of fighting to maintain their democracy. And that's where I would like to answer the earlier question, to find at least aspects of hope for the future.
Well,
Okay.
Decisions permitting the AK-15. No one should follow Dobbs' decision. You shouldn't follow the law in Florida.
Well, you're facing these issues, and let me just say, you're facing these issues that flow from Dobbs. You got the state legislatures now that are trying to affect, you can't travel from one state to another to get an abortion. You got now an effort to try and nationalize the right to control abortions. You've got this Mifepristone case that's up there now trying to knock this drug out. You got some battles ahead yet. It's very hard to say what the outcome is. I mean, it's still, the challenge is to keep trying. Nevertheless, hard for me to say defy the law. That's not my job, but you know.
Anyway.
Okay, yeah. That was a great presentation. I think we all enjoyed it.